If you have been waiting for your green card, watching the Visa Bulletin every single month, refreshing the Department of State's website, counting the days, hoping for some good news, then today's video is made for you. Because right now, in 2026, there are real movements happening in the priority date system that could affect when your green card actually comes. And if you do not understand what these movements mean, you could miss a critical window that might not open again for months or even years. So, stay with me because by the end of this video, you are going to know exactly what is happening in the Visa Bulletin this fiscal year, what it means for your specific category, and the concrete steps you can take right now to make sure you do not fall behind. My name is your host here at Immigration News Today, and for years I have been helping people just like you navigate one of the most complicated systems in the entire United States immigration process, the priority date system. This is not just about numbers on a government website. This is about your family, your future, and your place in line. So let us break it all down together, calmly, clearly, and with as much practical guidance as I can give you. First, let us make sure everyone is on the same page about what a priority date actually is. When you or your employer files an immigrant visa petition with USCIS, that is United States Citizenship and Immigration Services, you receive a priority date. Think of it as your timestamp, your reservation in line. It is usually the date when the petition was properly filed, or in employment-based cases where a labor certification is required. It is the date that the Department of Labor accepted the labor certification application for processing. This date does not move. It stays with you. And your job, from that point forward, is to wait for the cutoff date in the monthly Visa Bulletin to reach your priority date. When that happens, your priority date is said to be current, and that is when you can move forward with the final stage of your green card process. Now, here is where things get important, because the Visa Bulletin is not just one number per category. There are actually two charts that matter. The first is called the Final Action Dates chart, sometimes referred to as Chart A. This is the date your priority date must be earlier than in order for a visa to actually be issued to you or for your adjustment of status application to be approved. The second chart is called the Dates for Filing, sometimes called Chart B. This is an earlier date that, when authorized by USCIS, allows you to submit your I-485 adjustment of status application even before a visa number is technically available for final approval. The distinction between these two charts is enormously important, and the situation in 2026 is making it even more so. Each month, USCIS announces which chart applicants can use, and that announcement can change the entire landscape for tens of thousands of people almost overnight. So, what is actually happening right now, as of April 2026? Let us walk through it category by category because the picture is genuinely mixed. There is both good news and some caution flags worth knowing about. Let us start with the employment-based categories, because there has been a major shift that took many applicants by surprise. Through much of the early months of fiscal year 2026, USCIS had been authorizing the more favorable dates for filing chart for employment-based categories. That allowed a broad window for applicants to submit their I-485 applications even if their priority dates were not yet current on the final action chart. April 2026 was a transformative month for this reason. EB-2 worldwide went to current status, meaning applicants in most countries outside of India and China could file without restriction. EB-3 saw meaningful forward movement as well. It was, by many accounts, an unusually generous month in the Visa Bulletin. But with the release of the May 2026 Visa Bulletin on April 2, 2026, the Department of State announced a pivotal shift. As of May, all employment-based applicants must now use the more restrictive Final Action Dates chart, Chart A, rather than the Dates for Filing chart. USCIS confirmed this on its official adjustment of status filing charts page. What this means in plain language is that the broad filing window that existed in April has effectively closed for employment-based applicants. If you were preparing to file based on the more generous dates for filing chart and you have not yet submitted your I-485, you need to consult with a qualified immigration attorney immediately because the window is no longer open in the same way. Now, why does this happen? Here is the logic behind the scenes, and it is important to understand this so you are not caught off guard in the future. When dates advance significantly in the Visa Bulletin, as they did in April, it generates a surge of new applications to USCIS. The Department of State needs to watch how many I-485 filings actually hit the system before they decide whether to keep advancing, hold steady, or in some cases, retrogress the dates. May is what analysts often call a watching period. The system essentially pauses after a big move to take stock of demand. This is not a sign of failure or reversal. It is a built-in feature of how the numerical control process works under the Immigration and Nationality Act. For applicants from India and China in the employment-based categories, the picture can continue to be difficult as it has been for many years. EB2 India, after advancing by approximately 10 months in April to reach July 15, 2014, has held at that date in May without additional movement. EB3 India similarly remains frozen at November 15, 2013. EB2 China and EB3 China are frozen at September 1, 2021 and June 15, 2021, respectively. These backlogs exist because of a statutory per-country limit set at 7% of the total annual employment-based visa numbers, a limit embedded in Section 202 of the Immigration and Nationality Act. With India and China accounting for such a disproportionately high share of petitions, the per-country cap creates waiting times that can stretch for well over a decade. It is one of the most discussed structural challenges in the legal immigration system, and it remains unchanged by law as of this recording. There is also a specific warning in the May 2026 bulletin that EB5 unreserved India may face retrogression or be made unavailable later in fiscal year 2026. The Department of State specifically cited sufficient demand and increased number use. If you hold an EB5 unreserved India case with a priority date near the current cutoff, the guidance from immigration analysts is clear. Consult your attorney and consider filing without delay. Now, let us talk about family-sponsored categories because this is where the most positive movement in May 2026 is concentrated. Family-based applicants continue to benefit from USCIS's authorization of the dates for filing chart, meaning they can still use the more favorable Chart B for submitting I-485 applications in May 2026. This is significant and represents a meaningful opportunity for eligible applicants. The standout movement this month is in the F2A category, that is, spouses and unmarried children under 21 of lawful permanent residents. This category jumped approximately 6 full months across every country in the world. The F2A final action date has advanced substantially, and on the dates for filing chart, F2A remains current for all countries. If you are a green card holder with a pending family petition for your spouse or young children, this is worth your immediate attention. Check USCIS's official adjustment of status filing charts page and the Department of State's Visa Bulletin to see if your situation has changed. F1, which covers unmarried sons and daughters aged 21 and older of U.S. citizens, also saw solid forward movement in May, between 4 and 6 months for most countries. F3, which covers married sons and daughters of U.S. citizens, and F4, which covers brothers and sisters of U.S. citizens, also posted gains this month with the Philippines category for both seeing particularly notable advances. No family-sponsored category retrogressed in May 2026. That is genuinely good news and reflects what analysts describe as excess capacity in the family allocation for this fiscal year. So, what does all of this mean in practical terms? What should you actually do with this information? The first thing, and I cannot say this strongly enough, is to know your priority date. pull out your approval notice for your I-130 or your I-140, whichever applies to you, and confirm the date on that document. If you are not sure where to find it, check with the attorney or accredited representative who helped you file, or log into your USCIS online account where petitions are often tracked. Your priority date is the foundation of everything. The second step is to go to the Department of State's official Visa Bulletin, available at travel.state.gov. Look for your category and your country of birth, not your country of citizenship, but your country of birth. Find the relevant cutoff date. If your priority date is earlier than the cutoff date on the chart, your date is current or you are at least in the window for filing depending on which chart applies to you. If your date is later than the cutoff, you are still waiting. The third step is to check USCIS's Adjustment of Status Filing Charts page at uscis.gov. This is where USCIS announces each month whether applicants should use Chart A or Chart B. As of May 2026, family-based applicants use the Dates for Filing chart, and employment-based applicants use the Final Action Dates chart. But this can change month to month, so you want to confirm it every single month. The fourth step is to prepare your documents in advance. Whether you are waiting for your priority date to become current or it already is, the time between now and your filing date is not wasted time. Use it to gather the documents you will need. Things like your passport, birth certificates, police clearance certificates, medical exam results, affidavits of support, evidence of employment or income, and any prior immigration records. Document preparation can take weeks or even months in some cases. And having everything ready means you can act quickly when your window opens. The fifth step is to consult with a qualified immigration attorney or an accredited representative if you have not already done so. I want to be very clear here. Everything I share with you on this channel is educational and informational. Immigration law is highly individual. Your specific situation, your category, your country of birth, your petition type, your employment situation, your family circumstances, all of these factors matter enormously. What applies to one person may not apply to another. A professional can review your complete picture and help you make informed decisions tailored to you. Let me give you a real-world scenario to help bring this to life. Imagine someone named Priya, a software engineer from India who has been working in the United States on an H-1B visa. Her employer filed an I-140 petition on her behalf under the EB-2 category back in 2016, giving her a priority date somewhere in that year. Looking at the May 2026 Visa Bulletin, her category, EB-2 India, has a final action date of July 15, 2014. Her priority date of 2016 is not yet current. She cannot file her I-485 or receive a visa number right now. But she can continue maintaining her status, tracking the bulletin monthly, and preparing her documents. If movement continues and her date eventually becomes current, she needs to be ready to act quickly because the window can close as suddenly as it opens. Now consider someone named Maria, a green card holder whose U.S. citizen sister filed an I-130 petition for her years ago under the F4 category. Maria was born in the Philippines. The May 2026 bulletin showed meaningful forward movement for F4 Philippines. Maria needs to go to the official Visa Bulletin, find the F4 row, and look at the column for the Philippines. If her priority date is earlier than the cutoff, she may now be in a position to file using the Dates for Filing chart since USCIS is authorizing that chart for family categories in May. Maria should speak with her attorney right away because this kind of opening does not always last. One of the most important habits you can build as someone navigating this process is to check the Visa Bulletin every single month. It is released by the Department of State typically around the middle of the month preceding the month it covers. So the May Bulletin was released on April 2, 2026. The June Bulletin will come in May. You want to be looking at it as soon as it is released because USCIS then typically announces within a week or so which chart you can use. Between those two announcements, you have your window to understand where things stand and take any necessary steps. I also want to address the broader context of fiscal year 2026. The fiscal year for immigration purposes runs from October 1st, 2025 through September 30th, 2026. As we head into the second half of this fiscal year, May through September, the Department of State is actively managing how many visa numbers have already been used and how many remain. This is why you can see large forward movements in some months and then a pause or even retrogression in others. The goal is to use all the visa numbers Congress has authorized without exceeding them. And that balancing act plays out in the Visa Bulletin month by month. For fiscal year 2026, the statutory limit for family-sponsored preference immigrants is 226,000, and the worldwide level for employment-based preference immigrants is at least 140,000, as established under the Immigration and Nationality Act. What should you watch for in the coming months? Immigration analysts and legal professionals suggest that employment-based movement may resume after the pause in May, particularly in EB3 categories, and for applicants from countries other than India and China. The State Department needs to observe how many filings came in from April's broad window before it decides to advance again. If that surge does not materialize as heavily as feared, there may be room to move dates forward again in June, July, or August. For family categories, F2A may continue to advance given that the final action date has been closing in on recent years rapidly. And of course, the India EB5 unreserved warning from the May Bulletin is a live situation that could change at any point in the remaining months of fiscal year 2026. What you should not do is panic, give up, or make rash decisions without speaking to a professional. Retrogression, when dates move backward, does happen, and it is unsettling, especially if you have been waiting for years. But it is also a predictable feature of a numerical system that is managed month to month. The path forward is to stay informed, stay organized, stay connected to your legal support system, and take action when your window opens. Before I close out today, I want to briefly remind you of something that often gets overlooked. Your country of birth, for Visa Bulletin purposes, is not necessarily where you are a citizen or where you hold a passport. It is the country where you were born. And if you were born in a high-demand country like India or China, that determines which column of the Visa Bulletin you look at. In some situations, a person may be able to claim chargeability through a spouse born in a different country, a concept known as cross-chargeability, which can sometimes open faster timelines. Again, this is exactly the kind of nuanced strategy that an immigration attorney can help you evaluate for your specific case. As always, I want to remind you that everything shared on Immigration News today is for informational purposes only and does not constitute legal advice. Immigration policy can and does change, sometimes quickly and without much warning. The information in this video reflects the Visa Bulletin and USCIS guidance as of April 15, 2026. Please verify all details through official sources. That means USCIS at uscis.gov, the Department of State Visa Bulletin at travel.state.gov, and if you are unsure, please consult with a qualified immigration attorney licensed in the United States. If this video has helped you better understand where things stand with priority dates in the Visa Bulletin in 2026, I would love it if you would take a moment to hit that like button. It sounds small, but it genuinely helps this channel reach more people who are searching for exactly this kind of clear, honest, practical immigration guidance. And if you are not yet subscribed to Immigration News Today, now is the moment. We cover the Visa Bulletin every single month, along with breaking news from USCIS, DHS, and the Department of State, policy changes, and practical guidance that helps you understand your rights and your options. We are here every step of the way. Check the video description below for links to official resources, including the Department of State Visa Bulletin and the USCIS Adjustment of Status Filing Charts page. Share this video with someone you know who is on this journey because reliable information changes lives. Take care of yourselves, keep your documents organized, keep checking that bulletin, and we will see you in the next one.